Good afternoon, everybody. Thanks for joining NISAC for another webinar. We've got one that we got a request for based on the budget dealing with open meetings law, and happy to introduce, I think a lot of you already know, Kristen O'Neill with the Department of State, works in the Committee on Open Government, really an expert on all things open meetings law, FOIL, across for state and local government. There were a few items that were addressed in the budget dealing with changes or expansions to the open meetings law, and there's some confusion on, does this incorporate or is this something that is going to change how counties operate, and or any kind of agencies or things like IDAs that your county may work in tangent with, but not exactly a county department, but things that are within your community. So it's gonna be a relatively shorter webinar, because there were a lot of proposed changes in the budget. Only a few things passed. So if anything, this will clarify what made it and really just how little potentially this has to change going forward. That said, I'll be here, Kristen will be here for Q&A for even existing law. If you've got any questions on how things work for your open meetings and or FOIL within your county. And then we can always contact myself or Kristen at any time if you've got questions on this or any related matters. So with that, I'll turn it over. Thanks again, Kristen, for being here.
Thanks for inviting me, Pat. This budget caused me a little bit of agita and confusion, but I think Pat helped me finally figure it out. So the easier thing to figure out, because we were closely tracking it, was whether the extension. So in 2022, the extraordinary circumstances video conferencing provision, the open meetings law was passed by the legislature, and the governor signed that into law, which allows public bodies. It expanded the use of video conferencing by public bodies, but only under very limited circumstances. So here, the legislature in 2022 was showing a clear preference for in-person meetings, because the expanded use of video conferencing was really, not only was it under very limited circumstances, but there was a lot of hoops that needed to be jumped through in order for a public body to take advantage of these new provisions. So a public body could allow one of its members to attend from a private location that was not noticed, that was not open to the public, but only if that person was experiencing an extraordinary circumstances such as disability, illness, caregiving responsibilities. In order to take advantage of this provision, governing bodies of counties, towns, villages, cities needed to pass a local law. Other public bodies had to pass a resolution, and all public bodies, not just governing bodies of counties, cities, towns, villages, all public bodies had to have a public hearing first. So there's a lot that went into it. You have to have a policy, you have to have procedures. And again, the quorum requirements were still pretty strict. The people that were attending from those private remote locations did not count towards a quorum. That was set to expire July 1st of 2024. There was some talk about maybe tweaking that provision to loosen the quorum requirements. But ultimately, in this budget, the extraordinary circumstances provision, there was just a straight 2-year extender. That's all that the budget included. Now the language is exactly the same in the open meetings law. It's just that now, instead of expiring on July 1st, 2024, it's set to expire July 1st, 2026.
Kristen, it's a little confusing sometimes, because is there also a different provision? I think that provision allows a legislator or two or a board member or two in extraordinary circumstances, and if a local law passed, that they can be virtual if those circumstances are met. Is there still a method from past law that's continued, I believe, that a legislator or board member could be virtual if they put the spot they're at open to the public, allowing the public to know where they're meeting virtually and have that also be open to the public. That's still available, correct?
Correct. I call it the pre-COVID and the post-COVID. The way that we were allowed to take advantage of video conferencing technology before COVID hit, before the pandemic hit, is we're still allowed to do that. And we don't need to jump through all those hoops that were established by the amendment to the open meetings law in the legislation that passed in 2022. So, for example, I mean, the Committee on Open Government, I think, is a nice example because we've taken advantage of it for a long time. Committee on Open Government is an 11-member body with people that have been appointed to it that live all over the state of New York. And so when we have our meetings, we're administratively supported and housed by the Department of State. So we set up our meetings, we put out our notice, and we say we're going to have our offices where the meeting is going to be set up where members can attend from either Buffalo, Albany, or New York City. Here are the locations in Albany, New York, Buffalo, Albany, and New York City. The members can attend from the location that's most convenient from them, and the public can attend from any of those locations. Then we're going to connect all of those locations through the use of video conferencing. And so that was something we've been able to do for many, many years. And we'll continue to be able to do that without having to pass a local law, without, all of those people that attend from those open public locations, they all count towards a quorum. So none of these new sort of strict rules apply to that old way of doing things. If we could do it pre-COVID, we can continue to do it. And it also applies to situations in which you maybe have a county legislator who is on vacation, but is also willing to open their location. Maybe they're in Florida and maybe they go to a local library and ask the local library if they can use one of their meeting rooms and use that as a location. And the meeting notice states that this member is going to be attending from this location. And if any member of the public just happens to be also on vacation in this same locale, they're also welcome to attend from that location. As long as the meeting notice states where the member is attending from, and it is theoretically open to the public, whether anyone actually attends from that location is not really relevant, but it's just theoretically open to the open to public attendance, then all of these sort of new rules about extraordinary circumstances don't apply to that situation.
And it's interesting you say a library in that situation because it's the open meetings rules as far as reasonably accommodating space and taking into account those, say, disabilities or something can make it to that space as opposed to someone streaming from an apartment turns up or something. You still want to try to make it into a space that it would be accommodating to the public, correct?
Yeah, I mean, sometimes I think you just want to make it accessible to you don't want, like sometimes people use the example of airports. Airports just aren't accessible anymore. Maybe they were 30 years ago, but airports aren't accessible anymore. Restaurants are not accessible. Driving along in your car as you're traveling across country are not accessible. There's just lots of, gated communities while you're on vacation are not accessible. So you just want to make sure you're at a location that is accessible to the public.
So that law's evergreen. The one that was about to sunset that went forward is the ability for the extraordinary circumstances, the one you don't have to allow the public in for the one individual if they've got those extraordinary circumstances and you pass the local law.
Correct. Yep.
Okay.
So that one's extended for another 2 years past July. So July 1st, 2026. The second one that caused me a little that I was unsure of. It relates to state and local authorities. And my take on this is that it's a bit of a belts and suspenders amendment because there's already language in the Freedom of Information Law that specifically encompasses public authorities. The Freedom of Information Law governs access to agency records. That's the term used in the Freedom of Information Law. You access agency records. That's the legal term. And then it defines the term agency. One of the terms used in the definition of the term agency is public authority and public corporation. So then I backtrack, and so just, backing up a little bit, is in that same budget bill that extended the extraordinary circumstances video conferencing, there's also it's part SS subpart B of the sorry, that's me dinging, reminding me that I have a conference call with NISAC and that I need to take my daughter to the oral surgeon for an evaluation to get her wisdom teeth removed. She won't mind if I forget, but I will. So anyway, so there's the provision in the budget bill that amends the New York State Public Authorities Law to add a new section 2829 to, in my opinion, just clarify, probably codify, clarify and reinforce a pre-existing requirement. This is my interpretation. It's clarifying and reinforcing a pre-existing requirement that state and local authorities are subject to both the Freedom of Information Law and the Open Meetings Law. So the language states that all state and local authorities, as well as all subsidiaries of such state and local authorities, shall, to the extent practical, stream all open meetings and public hearings on their website in real time, post video recordings of all open meetings and public hearings on their website within 5 business days of the meeting or hearings, and maintain such recordings for a period of not less than 5 years. So basically it's saying they're subject to the Open Meetings Law and the Freedom of Information Law, but it also adds a little additional language that adds additional obligations that other agencies and public bodies don't necessarily have. The reason why
what are we talking about? We're talking like IDAs. Is that in agencies such as that, or entities such as that?
Industrial development agencies, I believe, fall under the definition of. So you have those, I believe, fall under the definition of local. I think those fall under the. I'm looking at that. So it's a local industrial development agency, as I think. I'm looking at the two definitions. There's two. One defines a state authority. So a public authority defines state authority as a public authority or public benefit corporation created by or existing under the Public Authorities Law or any other law of the state of New York, with one or more of its members appointed by the governor or who serves as a member by virtue of holding a civil service office of the state. And then, so that's a state authority. And then Public Officers Law Section 2, subpart 2 defines local authority as a public authority or public benefit corporation created by or existing under this chapter or any other law of the state, whose members do not hold a civil office of the state, are not appointed by the governor. So basically, you've got the state where the governing bodies appointed by the governor or hold a state level office. Local authorities have more subparts though. So you've got the public authority or public benefit corporations created at the local level. Then you have a not-for-profit corporation affiliated with, sponsored by, or created by a county, city, town, or village government. Then you've got a local industrial development agency, and I think that's where the IDAs come in. So it's a local industrial development agency or authority or other local public benefit corporation. Subpart D says an affiliate of such local authority, or E, a land bank corporation created pursuant to Article 16 of the Not-for-Profit Corporation Law. So those all fall under the definition of local authority under the Public Authorities Law.
So these public authorities now, and this is where I think there was some confusion on that end. So these are not necessarily county entities, right?
But you might interact
but
with them at the county level.
They might
Yeah.
interact, yeah. So let's like stick with like an IDA or something. I think there was always, so the Committee on Open Government has for years and years, they do a very good job. If you want to, those are listening, go to their website, they give opinions on certain matters. They have a number of opinions already on were entities such as this, do they have to comply with open meetings law? And the opinions of consistently over the years from your agency, Kristen, said yes. That's how we interpret the law anyway. I think to your point, this certainly codified that, right? These were opinions of the way the law was written, and then this clarified yes. If there's any question on that, yes they do, yes they are. And then so then for the second, the question I have for you on that, as long as you semi-agree with that, do you want to or agree with that? Does this, so there was some confusion from some of our members on what this ultimately did for them was, it sounds like they need to record their meetings. They need to keep those meetings, those recordings for make them public, keep those for 5 years. Does that mean that counties, towns, villages have to do this as well?
No. So this is not adding any additional requirement for county level government, for city level government, towns or villages. The only people this is adding an additional requirement for are state and local authorities like housing authorities, economic development corporations, local LDCs. Yeah, I mean, housing authorities is a good one. Someone just asked me about economic development corporation, IDCs you just mentioned. Those are the types of entities that are going to be required to the extent practicable, stream all their open meetings and public hearings on their website in real time, post their video recordings on their website within 5 business days, and keep them for not less than 5 years.
Okay.
But it will not affect county government, like a county legislature, a county board of supervisors. This does not impact them at all.
Again, the only thing that does impact those groups was the law we talked about before, the extender for allowing for virtual. Directly, right? Indirectly, if you're a board member of an IDA or or a public entity such as this, separately from your county functions, you will, if you weren't recording and streaming, it sounds like you will have to. And is this effective immediately? Do you know, Kristen, or is this?
The second one is going to, it said 30 days from the date it was signed, so it was going to be May 20th.
Yep. Okay.
Kristen, can I pass on a couple of questions while you're in this mode that have come in while you're talking on this particular topic? The first one just said, so county governments do not have to live stream all committee meetings, question mark?
There is no obligation under statute that I'm aware of that requires county governments to live stream.
Okay. And then the second one was, does the amendment to the public authority law pertain to land banks?
There is the definition of local authority appears to include land bank corporations. It includes a land bank corporation created pursuant to Article 16 of the Not-for-Profit Corporation Law. I am not an expert on public authorities, so please don't take my word for it on this. If someone needs guidance on this, I would maybe reach out to the authority's budget office.
And the last one is, will school boards need to record and post school meetings?
School boards are not subject to this new provision. That I can answer. Just keep in mind, this new provision doesn't does not apply to counties. This new provision does not apply to counties. This new provision does not apply to school boards. But just like, for example, the extension, the extraordinary circumstances, if you're taking advantage of those provisions, if you are taking advantage of the extraordinary circumstances, video conferencing provision, there's an obligation to record and post.
Yeah, it's when you have that equipment and you're using it. So if you do take advantage of the virtual, now you do have to record and keep those recordings, correct? Like for, I think, again, 5 years. So but if you don't have that,
If you have a completely in-person meeting as a county government, as a school board, if you have a completely in-person meeting with no virtual option whatsoever, then there's going to be no obligation to live stream or record.
Any other follow-up or any questions? Kristen, while we're waiting to see if anybody wants to type any other question, can you tell them what the best way to contact you is? If they've got any
Certainly.
follow-up questions from this or anything else?
So we're a tiny office. If you would like to speak to me or one of the other attorneys in the office, our telephone number is 518-474-2518. And the best email address to reach us, not that you're more than welcome to just email me directly, but in case I'm traveling for work or out and about, it's our acronym COOG, C-O-O-G, @dos.ny.gov.
Great. Any questions, Jeanette, come in? All right,
No, right
Hearing
now
none.
we have answered all questions.
excellent.
Oh,
I
here
told you
comes
it's short and sweet. Oh, it's not short and sweet. What do we got?
It's just a thank you from Tom Fagioni, Orange County legislator. Thank you for this informative webinar. I appreciate the info presented here. Thank you. And that, Kristen, is for you.
Very welcome.
So yeah, with that, let's wrap it up. I know there was a lot that was put in budget proposals, but not much ultimately ended up changing. It was two items. And so thanks, Kristen, again, for coming in and helping clarify that for our members and for being there for us.
You're most welcome. Thank you for having me.
Have a great afternoon, everybody.
Thank you. Bye-bye.